Have you ever really read the termination clause in your employment contract? I mean, really dug into it. Because tucked away in all that legalese could be a few simple words that might just turn that document into a potential gold mine. A recent court case has thrown a huge spotlight on some of the most common words employers use, and honestly, the result could completely flip what you're owed if you're ever let go.
So in this explainer, we're going to break it all down. First up, we'll talk about the severance pay trap that so many people don't even know exists. Then we'll get into the legal earthquake known as the Walksdale case. It really set the stage for everything. And that leads us to the main event, the at any time gold mine from the Dufault case. We'll cover exactly why this matters to you, and finally, we'll look at what's coming next in this, super fast-changing area of the law.
All right, so let's get right to the heart of the matter. When an employer lets an employee go without cause, the biggest, most immediate question is always, what do they owe me? And this right here is where a massive financial battle often kicks off. And really, it all boils down to this one question. Your employment contract is supposed to give a crystal clear answer. But as we're about to see, that answer might not be nearly as solid as your employer wants you to believe. The stakes here, they are incredibly high.
Okay, now this is where it gets really interesting. The gap between these two columns is just massive. On one side, you've got the absolute bare minimum required by law, the Employment Standards Act, or ESA. For a lot of people, we're talking just a few weeks' pay. But then, on the other side, you have the common law. This calculates what's called reasonable notice, based on your age, how long you've worked there, your role, the whole picture. And that can mean many, many months, sometimes even more than 2 years of full pay. Now here's the kicker. A well-written contract can legally slash your entitlement all the way down to those tiny ESA minimums, costing you a potential fortune.
For the longest time, employers thought they had this all locked down. But then, in 2020, a decision landed that sent absolute shockwaves through employment law. It's called Waxdale v. Swigan, and it completely changed the game. So what Wakesdale gave us is this idea called the tainting doctrine. And the logic behind it is actually pretty simple, but it is so powerful. It says you have to read the entire employment contract as a single package. And if any one part of the termination section is illegal, even a tiny part that doesn't even apply to you, it taints and knocks out the whole thing. The easiest way to think about it is this. One rotten apple spoils the whole barrel. Before Walksdale, a judge might have just crossed out the one bad part and kept the rest. But after Walksdale, nope. If there's even one little sentence that breaks the rules of the ESA, the whole termination clause gets tossed out the window. And that means, instead of getting the little bit your contract promised, you're suddenly entitled to that much, much bigger common law payout. And this brings us right up to the huge development from 2024, a case called Dufault v. Township of Ignace. It takes that powerful Waxdale idea and aims at some of the most common, everyday language you'll find in employment contracts, revealing that potential gold mine we talked about. Take a look at this. You've probably seen something just like it in your own contract, right? We can terminate your employment at any time in our sole discretion. Seems totally normal, totally standard. For decades, nobody thought twice about it. But the Dufault case zoomed right in on those 3 seemingly innocent words, at any time. So what's the big deal? Why is this a problem? Well, because legally speaking, an employer can't terminate you at any time, not even close. The Employment Standards Act has a whole bunch of protections. For instance, you can't be fired while you're on a protected leave, like a parental leave. You also can't be fired just because you asked about your wages or stood up for your rights. In fact, get this, there are something like 47 different rules in Ontario that can stop a termination in its tracks. So when a contract says you can be fired at any time, it's making an illegal claim. It's trying to get you to sign away rights that you're not allowed to sign away. And you can really see how this all snowballed right here. Walksdale kicked it all off in 2020, saying one bad part spoils the whole thing. Then you had cases like Hawkes and Rahman, which just kept building on it, making it clear that even smart employees can't be tricked into an illegal contract. And now Dufault is the latest, and maybe the biggest step in this whole evolution, going after language that is in so many contracts out there today. Okay, so I know this is a lot of legal history, but let's bring it back to what really matters. What does this actually mean for you? Why should you care? Because simply put, this new legal precedent could hand you an incredible amount of leverage. Here's why we're calling this a potential gold mine, and I'll break it down into 3 simple points. First, this at any time language, it is everywhere. Seriously, it's standard boilerplate that law firms have been pasting into contracts for years. Second, thanks to that Walksdale rotten apple rule, this one little phrase has the power to nuke your entire termination clause. And third, that is your leverage. It means the limits in your contract are gone and the door swings wide open for you to claim full common law notice, which, as we saw, can be a life-changing amount of money.
So what can you do with this info? First, and this is easy, go find your contract, dig it out, and look for those phrases, at any time or in our sole discretion. Second, just know that if that language is in there, the part of your contract that limits your severance might be totally worthless. And third, this is the most important part, if you've been let go, get an expert opinion. Don't just sign whatever they put in front of you. An invalid clause could be the difference between a few weeks' pay and a few years' pay.
Now, before you march into your boss's office, there is one more crucial layer to this whole story. As with a lot of things in law, the road ahead isn't totally clear. There's a bit of a cliffhanger. So here's the twist. The Dufault case got appealed to a higher court. And while the Court of Appeal agreed with the final result, the employee got the bigger payout, they got there for a different reason. They pointed to another error in the contract and, get this, they deliberately chose not to make a final ruling on the at-any-time issue. So that specific question is still technically up in the air at the highest level for now. So what happens next? Well, the entire employment law community is watching two other big cases that are all about this exact issue, Baker v. Van Dolders and Levy by Wayfair. They were both just heard by the Ontario Court of Appeal on March 26th of this year, and the decision from that hearing is expected to be the final binding word that will settle this once and for all. We're all just waiting on that ruling to drop. So, here's the bottom line. The ground underneath employment contracts has fundamentally shifted. What everyone thought was solid, ironclad language for decades is now being picked apart. And it really leaves us all with one big question to think about. Is your employment contract, the document that's supposed to guarantee your financial security, actually just built on a house of cards? It might be time to find out.